Hello everyone and welcome to 2026 and welcome to our first webinar Wednesday of the year. Fantastic that so many of you are able to join me live and obviously those of you who are listening again either via our website or via our YouTube channel. And it's fantastic to see lots of new people who found us as well. So thank you very much for making joining Webinar Wednesday, hopefully your New Year's resolution. So what are we talking about today? Well, today is an HR heads up. And as you can see, I am not on my own today. I am joined by partner in our immigration team, Stephen Hall. Welcome, Stephen. Thank you very much for joining me.
Thanks, Emma.
And I'll be introducing Stephen in a bit more detail later on. For those of you who don't know me, I'm Emma O'Connor. I'm a partner here in our employment team at Door Clayton, and I'm also head of client training. And if we are not LinkedIn buddies, then please do click on the QR code, pop your camera up there, and then we can become LinkedIn friends and you can find out everything about what we're doing, what we're talking about, events, invites, webinars, newsletters, you name it. So please do link in with me. For those of you who don't know Doyle Clayton, we are a specialist workplace law firm based in the city, in the Thames Valley and in Bristol, supporting clients across the UK, across Europe and also globally. We support clients with their employment and HR issues, their business immigration issues and individuals as well. We also support businesses with data protection, with pensions, regulatory advice, as well as employment training and lots more besides. So please do get in touch with us for employment, commercial, corporate and immigration advice. And I look forward to hearing from you all. I have an action-packed 2026 planned for you. And in particular, I'm launching lots of new training courses, which I can run either in-house for your managers or your HR teams, or I'm also offering individuals the opportunity to come and join me at an open training course where you're just able to book and join me. The first of those is coming up shortly. Well, it's coming up in March, and this is one where I'm focusing on probation periods. The spotlight is going to be firmly on probation periods, particularly as we move forward with that unfair dismissal change looming from the 1st of January 2027. So this is really an opportunity to train up your managers and of course your HR teams as well. Please do book on if you're an HR professional, but it's focused on managers. How can we engage managers in the probation period? How can we focus on having a good probation period, and how can we give managers the confidence to make those decisions at the end of probation? A really important topic and a really important course already running this for clients. So again, please do join me. You can join me in person or you can join me virtually. So please do look out for invites. Another really important topic is managers engaging, managers having the confidence to have those really difficult conversations. And as we know, the Employment Rights Act is really all about ER, employee relations processes. ER is back. And because of that, the focus is going to be on managers and managers being able to have those tough and difficult conversations. So again, please do join me on the 15th of April where I'm running an open course. Again, please do book on 2 hours, running this one virtually, again, focusing on how we can tackle those tough conversations. Again, this is going to be really important, and I can run this in-house for your senior leadership teams, for your boards, managers, or again, for your HR teams. So please look out for it. If you're interested in joining, then do get in touch with me. And as you know, the HR Masterclass, I love the HR Masterclass. It's one of my most popular courses. So again, these are the dates. Pop them in your diary. London, 13th of May, Reading, 3rd of June, and Bristol. I'm coming to Bristol on the 10th of June. So it'd be fantastic to see lots of you joining, booking up day-long course. If you're new to the profession, you've returned maybe from maternity leave or from family leave, you want to kind of, upskill and get in touch with what's been going on in your absence, or if you are, HR professional at any level, please do come and join us when the invites come up. So that's great. So what else? Well, next webinar, I'm really excited about this one. How do we get people to do what we want? Intriguing. It's going to be fantastic. So again, please do join up for that one, 25th of February, for our next webinar Wednesday. And again, if you're not signed up to receive invites, again, I've got details of how you can do that at the end, and I will be emailing everybody. And of course, you'll get the link to watch this webinar again. If that wasn't enough, DC Talks have just dropped my latest podcast, again, on a Employment Rights Act update. So again, find us on Spotify, Buzzsprout, but we've also just on Apple as well. So again, lots of platforms you can hear from us. Just a bit of housekeeping. Stephen and I are live. Obviously, as I've said, you will get the recording of this webinar. But again, just to really emphasize, and I say this every time, but we're not giving you any advice. This is a high level overview of what you should have on your HR to-do list on the radar. Okay, so we're not giving you a deep dive into the changes. It's really just an HR heads up and to start a conversation. Why that is because obviously many of the changes we're still awaiting a lot of the detail about. So to find out more, again, join us at later webinars. I'm going to be doing lots and lots of discussion. My March webinar will be on the April changes coming in. So again, there's lots of opportunity to join and find out more as we move through the year. But really, to stay up to date, join us at webinars, sign up to podcasts, and obviously to our newsletters as well. And I know the employment newsletter and the immigration newsletter as well. So it's just an HR heads up, and look forward to, again, if you want to find out more, then please do connect with Stephen or myself. Stephen, again, partner in our immigration team. Again, if you would like to become LinkedIn buddies with Stephen, again, please do click on the QR code. Where would we be without one? Stephen, as I've already introduced you, but introduce you formally, thank you so much for joining us. And I know that you've got a really full slide deck in terms of what's going on. So please do update us with what to expect in 2026, please.
Great, will do, Emma. So nice to meet you all. I know there's a lot of people here that I've met before, but for those who don't know me, as Emma said, I'm a partner in the immigration team, specializing in corporate immigration, but also personal immigration. So what we can expect, if we go to the next slide, I think probably what most people are talking about at the moment is earned settlement. So the biggest change to the UK's legal immigration system in 50 years. So that's what the government has said. Some people say actually, well, I think the end of free movement about 7 years ago was more, but this comes out of, I think this comes a very close second. So this really is a huge thing for employers and employees as well, because it affects them personally, but then for employers, this will affect you because it's going to increase costs if you have to sponsor people for longer. It may then mean that it's more difficult to bring people to the UK. It's more difficult to retain people, and overall more difficult to keep your sponsored workers happy if they think that it's going to take them longer to get settlement. So what is it? Essentially, it's a new concept. What the government has said is previously it was a fixed time period. So you came to the UK, you're on a skilled worker visa. Then what would happen at the 5 year mark? Usually, then, if there was no criminal convictions, most people got settlement at the 5 year mark. And a lot of people plan their lives around this. So at the moment, we're getting questions. Sometimes people are waiting to buy a house. Maybe they'll get a mortgage when they get settlement. Maybe they're going to have a second child. You get 30 hours free childcare. Lots of things your employees will be planning for this 5 year mark. So unbelievably important for the whole workforce. On the right hand side, you can see the basics here, but the baseline is going to move from 5 years to 10 years. We'll go into you can actually get it earlier than 10 years, depending on your contribution. There's a consultation period running at the moment, so all of this isn't set in stone. As we go through, I will indicate what I think may change or what the government may stick to. But essentially, the consultation is until the 12th of Feb, with changes likely to be April 2026. So once the consultation ends, we won't have much time before the new rules come in. So that's why it's important now, although everything isn't set in stone, you need to get started and you need to start thinking about this. Probably the biggest question we get, and I imagine a lot of you have got this already from your employees, is will this be retrospective? I think, unfortunately, the government seems to be very bullish on this, so it looks like it will be a retrospective rule. So you may have individuals who are on a route to settlement. They've had a legitimate expectation that they would get there at 5 years. And from April 2026, it may move to 10. So that will be a big blow. And I'll go on to talk about what we can do, probably, communication, support your employees, and just look at the ways that you can reduce that 10 years back to 5. Again, you probably noticed there high earners, 125,140 earning, and then people earning over 50,270, they could still get it at 5 years, and then your high earners can still get it at 3. So it's not all bad news. Some people will be happy. Um, we'll go on to talk about that a little bit more because anyone who knows the tax system even a little bit well, um, will recognize those figures. So they're the tax threshold figures, and what the government has said is it'll be taxable income, which is obviously different to gross. So if someone's salary sacrificing their pension, you may earn 126,000, but to bring it below the 100,000 threshold, you may have been salary sacrificing. So it's not clear whether that 125,140 will be gross or it'll be taxable income. At the moment, the consultation says taxable income. So we need clarification on that. So if you move to the next slide, please. So the proposal, so if you look at a little bit more detail, the headline is it's moving from 10 years, plus these three minimum standards. The first two standards I've got there in the boxes. So no criminal fictions, no money owing to the NHS, no tax debts. Um, that that's not controversial, I think, with the general public. I think that when people, and as well, the rules are sort of similar at the moment, that there is a good character requirement. So number one. Number two, this is a little bit trickier. So at the moment it's you need to have spoken English to level B1. That will increase to B2. Um, Again, for your US nationals, Australian nationals, New Zealand nationals, anyone from an English speaking country, um, they won't have to worry about this. But if you've got, your European nationals, Indian nationals, they will have to take the B2 test. It it's at intermediate level, so it is a step up. And what we've found is that especially with reading and writing elements, that can be a little bit tricky. So again, you may have to think about, do you need to help your employees with English language tests and practice tests to get them to that B2 level? Um, third, the third minimum standard, um, again, on the face of it, doesn't look that controversial, but this will also apply to dependents. So if the main applicant is earning 150,000, um, they could get they could get settlement at 3 years. But if they're dependent, for whatever reason, possibly they've taken a few years off for childcare or a career break, if the spouse isn't earning 12,570, essentially what you wouldn't do if you didn't have if you weren't in employment, then they may have to get settlement at 10 years. So that third point, there's a lot of consultation on that. So we're sort of hoping that may change because that is very detrimental to the non-working spouse. So there's lots of sort of little flies in the ointment that, on the face of it, those three criteria, the minimum standards don't look that bad, but in practice, you may find stumbling points, especially with the higher B2, and also it may not affect your employee directly, but it may affect their spouse. So something to think about. Next slide, please. So winners and losers, again, it may not be a very sort of nice way to put it, but there are clear winners and losers with this new with this new settlement consultation. So if we start off in the 5 year column, so again, good news. A lot of your employees will still get settlement at 5 years. So they will have the expectation they will have settled 5 years, and they still will do. Um, but only if they can show for the previous 3 years, immediately before the application, they've got a taxable income of 50,270. Now, again, I've talked about this before, but it seems to be a taxable income. So if you've salary sacrificed, you may fall below that. Um, and then good news for doctors, nurses, or teachers. So possibly in professions that would struggle to get to the 50,270, but are very important for public services, they'll still be under the 5 years. Um, the big winners, again, the high earners, if you can show for the 3 years immediately before the application, you've been earning again, taxable income of at least 125, 140, you'll get it 3 years. So if you think about this, you may have had a senior employee who entered in April 2023. They thought they were going to get settlement April 2028. When these new rules come in April 2026, they could possibly then just apply for settlement early. So you may get an influx of very happy high earners. So you're going to have to sort of balance this with your employee relations that um, some people are going to apply early and some people are going to have to wait a further 5 years to the 10-year mark. Um, so you're going to have to manage that from an HR perspective, and make sure your communication and your reassurance is good. Um, the other 2 points I think are less important because you can only pick one of these. So what you can't do is you can't say, oh, I earned 52,000, so that's 5 years. Oh, and I speak English to C1 level, I'll get it to four. So all you can do is all you can do is one of these. So I think what you'll find is if you've got people who are below the 50,270, they then may look to do charity work, volunteering. Again, um, we're unsure how that will work. Do you get a letter from a charity? How many hours do you have to work? Is it only certain charities that have to be registered? So that reducing it to 5 or 7 years may be something that your employees want to do. But then you got to think about, do you have to give them time off? Do you help them find volunteering work? So that's got a lot of HR issues as well. Um, if there's no reducing combinations that you can get, then if you have a degree level C1, you could get a 1 year discount from the 10. So a little bit better, but still 9 years is still quite a long time to wait if you thought it was going to be five.
It'll be
Um,
interesting to see whether there's a lot of companies I know have, corporate social responsibility programs. So a lot of clients actually already run, community projects and charities. It'd be interesting to see if that actually would count towards the volunteering as well, because it might encourage more businesses to do, the kind of corporate responsibility work.
yeah, exactly, Emma. And there's also some charities who have said that I suppose they want people to come with a good heart and they want to volunteer.
Yes, it's
Or you
true.
you you may get some people who volunteer in order to just get settlement, and
Mm,
they may not be the type of volunteers people are looking for. So I think the charity sector is a little bit um, worried about this as well because they don't want to be signing letters and they don't want to be policing stuff for the Home Office. They don't feel it's
yeah,
their
it's
job.
true.
So it's quite
Yeah.
yeah. So on both sides, I think that bit's difficult. Um, a lot of clients have said it's fine, you can find time to volunteer. But if you're a French national and you've got three children, it's going to be really difficult to carve out that time. And that's when there might be an HR request for flexible working. Um, and you need some sort of policies about that. So yeah, it's going to be, yeah, it's just going to be a lot of work. And there's a lot of sort of like things that will transpire that maybe we haven't thought about.
Yeah, agreed.
Um, and then if we go to the next slide, this is less good news. So So it can be more than 10 years. So on the bigger scale, 30 years, I think what a lot of people are saying there is I think that what the government's saying is that if you've entered the UK illegally or if you've overstayed your visa, um, that's a long time, almost to the point of I think that's saying you're not getting it. I mean, will someone with 30 years? 20 years, again, this seems like a harsh rule. So people who have received public funds for more than 12 months. So again, what that's saying is if you've gone through a period of your life where maybe you did need to rely on benefits and things like that, even for just a short period of time, you're looking at 20 years. 15 years if you've received benefits for less than 12 months. Again, quite harsh. But one thing that maybe has slipped through the net that employers need to know is that there's a lot of people sponsored, especially from 2019, you could sponsor someone in what was called like a medium skilled job, so RQF level 3 to 5. Now this changed in July this year, so it does have so a lot of your people will be at RQF level 6, which is basically degree level. But there are jobs that, especially in sort of construction, manufacturing, hands-on jobs that are considered by the Home Office to be sort of more manual. So, for instance, maybe a pipe fitter, a welder, they would be although very skilled and also difficult to get. They would be
Mm.
classed at RQF level 3 to 5, which means you would have to sponsor them for up to 15 years. So the costs, the the employer's costs have trebled. So you thought you were going to sponsor someone for 5, and now it's gone to 15. So those roles below RQF level 6, again, that's another fly in the ointment for employers, because can you persuade people to come to the UK if it's going to be 15 years to settle? And if you can persuade them to come, you've got a lot more fees to pay. So if you think about a 5-year visa for a medium to large sponsor, you're looking at about 14,000. You're going to have to multiply that by 3 to get them to 15. So
Goodness.
it's a lot of
Mm.
money. It's a lot of
Mm.
money.
Yeah. Yeah. A lot of considerations.
Yes. So I'll just sort of put together a few points of what you can be doing now. So as I said, the consultation is running at the moment to the 12th of February. Hopefully, we'll find a little bit more about what do they mean by taxable income. What happens if the dependent spouse isn't working? Do they still need to make that? Do they still need to meet that 12,000 uh, for their application? So there's a few things still we're not sure about. But what you can do is so undertake an analysis of all your sponsored workers, because if someone can get settlement before April, they should definitely apply now. The current rules for most people will be more advantageous. And you can also apply 28 days before the 5-year period. So anyone who can apply should apply now. So what you don't want to do is get to May and realize someone could have gone under the old rules just before these came in. So definitely do that. And again, as I said, budget. I mean, I think you need to be talking to, the CFO or, the C-suite and saying, look, we our costs may be doubling because we thought it was going to be 5, it's going to be 10, could be tripling for your medium skilled. So that I think if I was an HR professional, I would be sending an email to the CFO and saying, just to give you a heads up, our budget for visas in 2026, 2027, 28 may be at least doubling. So do that. Also, I think audit your current salary bandings, because and once we find out about whether it's taxable income or is it actually did the Home Office actually mean gross, um, the 50,270 and the 125,140, if you can possibly tweak your salary bandings to try and get your skilled workers above that, um, then that would be really useful as well. So that would be for future planning. Um, Again, reassure and communicate. So what we're talking about today is, and what we've got is what we'll send through as well as the slides. We've got like a handy FAQ, that all the questions that we're getting asked, we've put it in an FAQ, and also what what services that we can provide and how we can help you to manage this. But I think probably from the outset, once the consultation, I mean, you could do it now as well, but once the consultation ends, a well-drafted comms just to say, we're going to support you, and we're taking advice on how we can help you to get settlement as early as possible. That would really reassure your workforce. Also upskilling your HR team. So as Emma talked about, we provide HR training. So if your HR team needs training on what this means, then by all means do that. And lastly, consider responding to the consultation. So there's a link here. I think I think the government is going to listen. So the more weight we can get behind certain things, and certain things that again, it's you can reply to that as a business, you can reply to that as an individual. So yeah, I'd encourage everyone to reply to the consultation and give your views.
Perfect. And we'll send that link out in our sort of post-webinar comms so everyone's got that. Good point.
Great. So yeah, so I went through the earned settlement quite quickly. We'll do more on that throughout the year. But
Mm,
that you've got, I think that gives you a really good idea of what the direction of travel is, and most of what I've said today will happen, and there'll be certain tweaks that the government may do. And the number one question obviously was, will it be retrospective? I think we have to be prepared for it being retrospective. Um, so moving on to a completely new topic, and this is sort of, in a sense, flying under the radar because the earned settlement announcement was such a big thing. There is there's a new act that got royal assent just before Christmas in December, and it's to do with your right to work obligations. So we'll all be aware that at the moment, an employer only has to take responsibility for the right to work for their employees. So someone who has got an employment contract or is an apprentice. Um, and then what the usual situation is, if you've got contractors, you would then cover yourself for your reputation on putting really good, strong warranties in your contracts to say, okay, we're doing a project with you. There's 20 people coming to our site, but the employer of the person that you've got the contract for services with, they will they will give you a warranty that everyone has the right to work, and that's been the case for years. What this new act now does is, and to put it in the context why the Home Office have done this is, in the gig economy, there's lots of employers who are not doing the right to work. So, but they're going to change the rules for everyone. Now, we haven't actually got the new guidance on what exactly this will look like. But what we think they're going to say is that if you've got a contractor, it doesn't matter if they're not your employee. If you've got a contractor on your premises, you need to make sure that person has the right to work. So if you think about this, that operationally and your resource strains on HR and onboarding, that's where the pinch will be. So you've probably got line managers involved, onboarding, operations, maybe legal who've done the contracts. So that's a really big change that will be coming into force in 2026. We're not sure when. So what you need to do now is maybe have a think about, okay, how are all our employees are the right to work checks done on them? Also, um, who's on our premises? Like, how many contractors have we got here? Um, do we need to recruit or onboarding people? Because you may have to sort of double the amount of right to work checks you do, depending on your industry. So if you've got a huge supply chain, especially project work, construction, defense, these huge projects, you may have to do a lot more right to work checks. So we'll probably do, once that becomes more apparent, we'll do a lot more on that topic. But again, there's probably lots as well to do with employment law on that as well.
yeah. And certainly there's there's a question actually might be worth just dealing with that now. What's your view on periodically, redoing the right to work checks? I suppose for employees, but obviously if that's broader.
Yeah, so with periodically so the immigration rules are quite clear that, well, once you've done your right to work check, you've got a statutory excuse until the visa is due to expire.
Mm,
So I think it's important once you do your right to work check correctly and you've taken the correct documents and you've got a correct record, you do have a statutory excuse to the maximum fine of £60,000. Um, but this new rule, essentially this new law that's going to come in some point in 2026, just brings in the whole supply chain. So it's all it could be
mm.
front desk, um, reception, sometimes outsourced, cleaning's outsourced, some construction work might be outsourced. So yeah, so there's a lot to think about. There's a lot to think about.
Yeah, exactly. We've had a couple of questions in on this. I think we'll I think definitely that sort of fact sheet is worth putting together on that, and I can see lots of issues as we arise as we go forward and until and until we know this is coming in. But yeah, huge change, huge issues, huge obligation as we've got there, the huge risk.
Yeah, exactly. And the reputational damage can sometimes be more
Mm,
than the
yeah.
fine, especially if you're a household name. Um, Newspapers like to publish things. So it's not just,
Mm,
I mean, it's £60,000 per illegal worker. So that is
mm, mm.
significant because it's per person. But the reputational damage can often be worse.
Absolutely. Yeah, definitely one to watch there. 2026 is certainly going to be a huge year. And
Yeah,
another big change as well that we've got coming in pretty imminently, it seems.
yes, yes. So again, um, global business travel. So all your business visitors. So if you're a global company, there's you'll have lots of people be just coming to the UK for a couple of days, flying in, flying out. In the past, it wasn't really tracked, but of course, last year we had the electronic travel authorization, so the ETA, a little bit like essentially like the US ESTA, and what that meant was any visitor who doesn't hold a visitor visa, uh, your US nationals, Australian nationals, New Zealand, all of Europe, they have to get this ETA. So it's actually quite an easy process. It costs £16. You do it on the app. Um, this wasn't mandatory in the sense that you could have still quickly applied for an ETA even if it wasn't approved. The airline would let you on the plane. So the ETA basically gets you on the plane. So from the 25th of February, this will be fully enforced by the UK, which means the airlines will also fully enforce it. So it's about boarding. It's about someone boarding an aircraft in Germany and being asked for their ETA. If they don't have that, they don't get on the plane. So this could be for your business visitor population. You need to make sure that they've got this ETA in place. The EU is actually going to do a something very similar called the ETIAS, just to be confusing, the ETIAS, and that's been delayed 4 or 5 times. So they are saying it's going to be late 2026. Let's see what happens, but it's also going to be someone going from the UK into the EU for everyone. So even if it's not for just business, it's for personal travel as well.
And
Um,
just
yeah.
and on that, is that every time you come from the US to the UK, you have to apply for an ETA, or can you just do like is it like a monthly pass or a 6 monthly?
And they're valid for 2 years. So yes, so
Oh,
it's
okay, fine.
yeah, so it's just once. So I suppose the actual doing the ETA doesn't take up too much
Mm,
time, but I suppose there just needs to be a mechanism, so it needs to be linked to possibly your travel expenses, or
mm,
somebody needs to do it. There is there'll be a few people caught out by there's a questionnaire saying have you about criminal convictions, and you may find there's some, let's say a US national who had maybe they when they were at university, they had a criminal conviction, and they've just never been asked that question for 20 years because they would just got a US passport, they would turn up at Heathrow, off they go. Because they have to do this ETA, they may get asked questions about their past that didn't matter before. So you may have a few employees that maybe they may need a little bit more help because they'll need to actually apply for a full visitor visa rather than doing the ETA. So you just take that on a case by case basis.
Yeah, certainly. I think that's another one to watch, isn't it, on that? And again, I can see we've had some questions, and so again, we'll follow up with those after the session if we are able to. So
Yeah,
thank you very much. Thank you
great.
very much for those.
Cool.
Goodness, what a busy year in terms of immigration and employment, as we know. And for those of you who've been joining webinars before and reading articles, you'll know that it's going to be a busy few years in the world of employment. I'm going to be talking lots more about the changes, so don't feel that you have to scribble, everything down now. But I do think it's worth just having that sort of overview of, where are the pinch points going to be, what do we need to be thinking about, and also the context. And actually, what Stephen's been talking about as well, the immigration changes, these changes to right to work checks, all of this uncertainty, this is the backdrop, if you like, to the changes that are coming in and what that means overall. So as we know, budgets are going to be squeezed. We've got this uncertainty, when are things coming in? When do we need to do stuff? And also, what's the detail? Because yes, we might know the headline, but we're still waiting for a lot of the detail. And as we've seen, we've got consultation coming up for immigration changes. We've also got consultation coming up for the Employment Rights Act changes, not just the Employment Rights Act changes. We've got those other changes that we generally have, rate changes. So April is going to be a big year. Also, what can we do? Budgets are squeezed, but how can we still attract the talent? How can we still retain the talent? How can we do more with sometimes less? So how can we train, develop, invest in our people? And again, what Stephen's talking about in terms of, investing in our people that maybe need sponsorship. Again, how can we make that work in the business overall? And what do we need to do, particularly around looking at salary bands and auditing your staff? Yeah, auditing who works for you, how do they work for you, is going to be a really important message. Again, not just in terms of immigration, but in terms of working in general, 0 hours, low hours, agency staff, how is that all going to look? Also, are you a job hugger or a job or a frog hopper? Have we got people who are, clinging on to jobs and maybe aren't particularly engaged? Or have we got some people who are hopping around jobs trying to find something that they're not finding with you? So again, lots of sort of cultural changes, uh, generational themes, who's looking for what, who wants what. And again, this is all about the backdrop to what HR teams are having to juggle with in terms of legislative and immigration changes. And again, fundamentally, how do we engage? How do we create those places, those workplaces where people want to join, they want to stay with us, and they want to thrive? So again, creating happy workplaces is again going to be a huge theme. You will know there is only one topic. Sorry, Stephen. I know there are lots of topics, but there's only one topic really. The Employment Rights Act. It's all happening. It's all go, go, go. Passed in December, 18th of December, finally got that royal assent. The will they, won't they be able to make it pass? And we saw there's changes that happened immediately, particularly with regards to strike action, the repeal of the Minimum Service Act, and also some changes to the Trade Union Act as well. So changes in December immediately around trade unions. Again, we've got some changes in February. Again, this is going to impact, again, mainly trade unions and strike rights, individuals who are striking. So again, expect some changes there. So we've got some, changes to look out for in February. Again, we're talking a lot more about those in detail. April, what to watch. Again, collective consultation, that protective award. This is going to be huge. Protective award increases to 180 days, actual pay per employee affected. So again, that's going to have a big impact on those of you who are contemplating those larger scale redundancies. We're going to have to revisit our family leave policies as well. We've got some changes coming in, particularly around parental and paternity leave, and some shared parental leave changes. And also look out for a new piece. It's been sort of knocking around for a while, but it came into force in December, focusing on parent bereavement leave. So what happens in circumstances where wife or a partner tragically dies either in childbirth or within 12 months of the child's birth or placement for adoption. So again, one to watch out for. And again, I'll be providing a little bit more detail on that, on what that means and what we need to do in terms of, processes. But it's looking like there's going to be an unpaid leave element of up to 52 weeks. So again, we need to think about how that works overall. SSP changes, and I think this is going to be a really big one and one to watch. And as we know, the waiting days will go, so SSP will be payable as from day one on the 6th of April 2026. So again, if you've got somebody who maybe didn't qualify because they were on the lower earnings limit, the lower earnings limit is going to go. So it's going to, I was reading, it's, 1.3 million workers are going to be now entitled to some form of SSP. Again, it's not, it's going to depend on if you are caught, if you are a lower earnings worker, yes, you will be entitled to some SSP, but at 80% of the flat rate. No one's going to earn more than the flat rate of SSP. There are some transitional provisions, but we did have one question in around is even though SSP is going to be paid from day one of sickness absence, is there going to be a cap? That 28-week cap will still apply to the payment of SSP and also the link provisions as well. So you've got that 56-day link provision, which will still stay. So SSP, training for managers, absence management, triggers, sick pay. Again, all part of the mix that we're going to have to look out for. And please remember April rate rises. And maybe for the last time ever, we will see the compensation cap for unfair dismissal increase for one last time before, as we know, it will disappear from January 2027 and have some huge implications there. Other April changes, sexual harassment, again, some whistleblowing protection there. The Fair Work Agency is going to be established, and that's going to take over some of the HMRC regulatory work, particularly around national minimum wage. Enforcement powers there, but again, do watch out for where the Fair Work Agency is going to go in terms of its power and establishment. And again, some trade union rights, recognition process, and the introduction of e-balloting. We're going to see lots and lots of changes to trade union rights of access to being able to have facilities within your workplace, recognition. So again, trade union rights are going to be one to watch. Gender pay gap, it's coming April 2025, obviously, but we've got that snapshot date of April 2025. But again, we've got the reporting procedures. So again, what was our mean median pay rates and our bonus rates between men and women, again, during those snapshot dates. Very, very quickly, again, October is going to be a big month for employment law and maybe immigration as well. Thinking about, we've got some dates that we're not sure at the moment when these are going to come in. I think the big one there, well, they're all big, aren't they? Harassment, third-party harassment, sexual harassment, raising of the bar, all reasonable steps. If you haven't had your contracts reviewed, again, I can't stress that enough, because those fire and rehire restrictions are going to really bite for employers wanting to make those restricted variations and dismissing as a result. I think, again, it's big, the extension of the time limit to bring employment tribunal claims from 3 to 6 months. I'm talking to clients about this now, and it's having implications in terms of data retention. How long are we keeping documents for, let alone what impact that's going to have on tribunal claims and the listing of those tribunal claims as well. And again, the focus is on January 2027, the 1st of January, where we've got that reduction in the qualifying period of service for unfair dismissal. It's going to reduce from 2 years to 6 months, and that overall cap for unfair dismissal compensation will be removed. Will have a huge impact on individuals who are high earners, going to have an impact on those individuals who maybe are going to take longer in terms of finding other work. So again, we've got lots to do, but January 2027 is obviously going to be a big focus month. And then we've got more changes that are coming in 2027. So I know there's a lot that we need to be focusing on. please stay up to date. My March webinar will be looking in a lot more detail at those April changes, particularly with SSP, because there's some transitional provisions that we need to focus on. So I'll be doing some nice, what if this, and some nice scenarios there. Also, I can't stress the training enough, managing probation, tackling tough conversations. I'm also doing update sessions for managers, particularly around the ERA changes and what they need to know about. This is all about management engagement. This is not an HR thing. We all need to be focused on these changes because your managers are the key to the success of your processes and also supporting your people as well. So review your contracts, and review your policies. That is really, a no-brainer. The training as well, particularly sexual harassment, third-party harassment, again, is an essential. And again, focusing on that EDI risk assessments, again, for sexual harassment. Auditing your staff, again, particularly from an immigration perspective, but as well focusing on, 0 hours, low hours workers, and when those changes will come in later in the implementation timetable. And again, really thinking about probation periods, embedding those strong performance management cultures. I'm doing lots of work with clients on their performance improvement policies, lots of training for managers on how we can effectively manage performance. It's not just, once or twice a year. It really is a 24/7 exercise, but focusing on the evidence as well. What evidence do you have to support the decisions that you're making? And again, that's echoed as well, I think, with the immigration, making sure you've got the evidence to support those right to work checks. So there is lots to do. It is being broken down. I think the focus really now just needs to be, we've got some months before April. What does that look like? We're here to help you. So again, please do get in touch with us. So we've had lots of questions. There are lots that we don't have the time to focus on. But Stephen, were there any questions that had come up that you wanted to deal with? Now, there was one
Uh,
around I don't know about the record keeping, if we know enough detail. Obviously, we have to keep records for the employee searches. Do you think we're going to have to keep that same level of record keeping for the contractor searches as well?
yeah, yes. So the at the moment the act would indicate that. So but I think it'll be less strenuous in the sense that if you're given a I think the contractor could give you a copy of the right to work. So at the moment it's not clear whether do you have to see the original document. So obviously if it's an employee at the moment, you need the original document and take a copy of that. But if the contractor does the right to work, I suppose previously they'd say, yes, I've done it, and you say, great, and then there's a contract to say that. Where I think now you will have to physically see the copy and then keep that on file.
Yeah. Okay. So again, some known unknowns, but we think that we've got, that there's going to be definitely some process work that we need to do. Stay in touch, please. Here are our email addresses if you want to reach out and find out more about how we can help your businesses. And again, this is just an HR heads up. We will be, dealing in things within a lot more detail. So please do stay tuned. And also please, sign up and join one of the training courses. It would be lovely to see you either in person and virtually. And I know Stephen and his team have got some plans to run some bespoke training as well. So again, there's lots of opportunity for you and I and us to all engage with each other. So until we have an opportunity to speak next time, I really hope you found that useful. Thank you so much for the comments as well. It is much appreciated. You will get the link to share with your team, so please do that. But it really leaves me to thank Stephen for joining me today. Thank you so much.
Great, thanks, Emma.
Goodness me, we've got busy years. Let's all take deep breaths. Until we see you next time, thank you again and hope to speak to you all soon. Thank you very much. Bye bye.